Garden State GSCLE. 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 Garden State GSCLE.
Now, is he a second refusal or is he a first refusal? He's never refused before. The only reason he gets second refusal treatment is because it's been enhanced, because it was in connection with a second or subsequent DWI. Again, I'm not advocating anything here. These are just unresolved issues. Your argument's going to be he's a first refusal, okay? Notwithstanding the fact he got this increased suspension, he's never been convicted of refusal before. This is the first time he's been convicted of it.
So here's the argument. On your first suspension, you're suspended for 6 months, but you get stopped 7 or 8 months into that 6-month suspension because you never paid your restoration fee. Now, back then, that was considered a refusal, that you were on the revoked list due to a DWI. Bob will tell you.
Perry, State versus Perry.
Perry will tell you that now they've changed Zalta's interpretation in Perry, and what they said is, if you get a 6-month suspension, for the purposes of this statute, that DWI, being suspended for a DWI, ends at 6 months. Even if you don't get your license back for 3 years, you don't pay the restoration fee. From that point on, you're suspended for administrative reasons, not for the DWI. And that's what Perry says. So that's, now Zalta, of course, over the years has said completely to the contrary. So your argument is maybe on the first one, I really wasn't suspended for that reason. So this is my first suspension for driving on the revoked list due to a DWI.
We'll get into it, guys, okay? Because I had never thought about it in those terms, but I think you're onto something. All right, subsection C. This is what I'm saying. You know, there's so many permutations here. This has to play itself out. C is strictly sentencing. We'll devote ourselves to sentencing. At this point, you all know that there's a minimum mandatory. It's a 4th-degree crime. 6-month parole disqualifier on that. We'll talk about that momentarily. All right. Now, the constitutionality of the statute has been subject to consideration by the appellate division. Carrigan is the case. The main issue on the constitutionality challenge dealt with ex post facto application. Basically, that the people who have been placed on the revoked list weeks, months, decades ago are now being penalized with this new statute without any notice to them. And it violated the ex post facto provisions of both the United States and state constitutions. That was rejected roundly by Carrigan. So that ship has sailed. Effective date of the statute, although it was enacted in 2010, is for offenses occurring on or after the 1st of August 2011. Now,
the rule of this case is the old Latin dictum, ignorantia lex est non excusat. The fact that you were unaware that they changed the law in the interim, that's not an excuse. You're supposed to keep up on the state of the law. Now, of course, as lawyers, we can't even do that. Can you imagine some guy working at the factory down the street? I think they amended 450, didn't they? That's my recollection.
Let's go back to the statute for a second. Notice that in the statute there is no culpability state set forth, and yet when you read it over, it does not appear that the legislature clearly intended that this be a strict liability offense. Typically, when the legislature wants something to be a strict liability offense, they'll use words like shall be strictly liable or things of that nature. So when you think about strict liability for drug-induced death or felony murder or the school zone drug distribution, possession with intent to distribute in the school zone, there's no doubt anybody reading those would know that it's a strict liability offense. Here, it's not clear that they intended it to be a strict liability offense. Now, that's very important because when the legislature does not utilize or doesn't specify a culpability state in a criminal statute, then you are to utilize the default position is knowing, all right? Here's the idea. It's under C here in your notes. Although no culpability mental state is expressly designated in a statute defining an offense, a culpable mental state may nevertheless be required for the commission of such offense with respect to some or all the material elements if the prescribed conduct necessarily involves such culpable mental state. Now stop. Please put a cross-reference in your notes right now after the word mental state to a published appellate division's case called State versus Sylvester that will be coming to, just like the cat, State versus Sylvester, which will bolster this in the context of 2C 40-26. All right? You'll see that momentarily. I just want you to have a cross-reference. Statute defining a crime, which is what we're dealing with here, unless clearly indicating legislative intent to impose strict liability, which I argued is not here, should be construed as defining a crime with a culpability defined in B2, which is knowing. All right? Now, I commend to you the case of State versus El-Dakari. El-Dakari is not a 2C40-26 case. It's some other statute. But the statute in El-Dakari also did not have a culpability state set forth. The defense attorney went and got a copy of the transcript of the grand jury instructions that was given to the grand jury by the assistant prosecutor. And the assistant prosecutor did not instruct the grand jurors on this idea that they would have to find that the defendant acted knowingly with respect to a material element of the offense and returned an indictment without that. Grand jury indictments that are produced as a result of deficient or wrong instructions by the assistant prosecutor are very poor candidates for rehabilitation. So the defense attorney moved under Rule 3:6-6B to dismiss the indictment granted at the law division level, sustained by the appellate division. If you're going to file a motion to dismiss an indictment on a 2C40-26 because of poor or inadequate grand jury instructions, El-Dakari is the case you follow. It's just a blueprint for how you frame your argument. Just follow it all the way through, and you should have the same level of success. Joe, I know you're not a big fan of this because of how easy it is just to represent these cases, right?
Well, yeah, and anyone that knows grand jury process is, if they suppose the prosecutor down in the grand jury doesn't realize that there's a knowing element. By the way, there is no case saying, as Bob just said, that there's a knowing element to this. It's just an application of other portions of 2C that say if there is no mens rea stated, we'll assume that it's knowing. However, although there's no case law on this, the standard, the model jury charge compiled by the Criminal Practice Committee of the Committee of the Supreme Court did a model jury charge, and that model jury charge says knowing. It's knowing is all through it, that the offense must be committed knowingly. So if you're going to try one of these things on the Superior Court level, you should know that committee, that subcommittee of the Supreme Court has in fact said knowing is the mens rea for this offense.
You'll see in the dicta we'll take a look at from the Sylvester case too, that they discussed the requirement that the defendant has to know certain things.
But now let me just tell you trial strategy on this, because there's, how difficult a case is this for them to prove? They bring in 2 judgments of convictions, let's say for 2 prior DWIs, and the cop says, I saw him driving. That's it, okay? Here's what I'm going to suggest to you by way of trial strategy. Yes, I could, in my case, that was in fact my defense. Now, the grand jury was never instructed as to knowing down below in my case. And I knew that I could go in there and have that indictment dismissed. Now, the prosecution, and what they can do, if they choose to do so, is they can go back into the grand jury room, have a detective read the transcript of the first grand jury presentment, and then just charge the jury as to knowing, and then have a new grand jury decide on that. Now, that's all you have to do. So it's really a half-hour effort for them. So if you raise this, oftentimes they won't even argue the motion. They'll just go back, spend a half hour, represent it, come out with a superseding indictment. So you're not really going to get any traction out of this unless the prosecutor's wavering and they don't want to go back. But I mean, most of the time, you're not going to get any traction with this. Now, in my case, since my guy presented a current and valid New York driver's license when he was arrested, and he just gave it to the cop. He didn't say anything, and the cop says, where's your New Jersey license? He says, I don't have a New Jersey license. I moved to New York. Here's my New York license. And then nothing else was said about that. And here's an interesting fact. The cop says, well, your license in New Jersey is suspended. I don't know whether New York license is good. And you have a DWI suspension. So I'll tell you what, follow me back to headquarters. Swear to God, follow me back to headquarters, and so he has a client drive back to headquarters. Now, no good deed goes unpunished. I want to shove that up their butt. Even a cop didn't know whether his license was suspended. How do you expect him to know? Because the statute says if you're driving on a suspended license. My argument was his New York license was valid. Do we know they have to prove beyond a reasonable doubt that he knew that he didn't have the right to drive on a valid license? Statute only says license. It doesn't say your New Jersey license. He had a valid license. It wasn't knowingly. Now, that was my argument. And I have to tell you, I got a lot of traction with the jury. They didn't return a verdict for an hour. So I really made headway with that. Otherwise, I might have only been back in 55 minutes, but I kept them out for an hour. But my point is this. I had to make a decision. Do I try to uproot the indictment? But if I do, I put everyone on notice in this case, and they have to prove knowingly at trial. So I talk to my client, tell him what my issue is. He says, okay, if that's what you think. I send him a letter. I put a file memo that I discussed this with him. We're not going to file this motion to dismiss. It's a matter of trial strategy. We don't want to alert them to this issue. Maybe they won't prove it at trial. Maybe they won't be directed towards it. And then at trial, we made this argument. Now, it was unsuccessful, but it's all part of trial strategy. I thought I had a much better chance of convincing a jury that he didn't drive knowingly, that he knew that he couldn't drive in New Jersey, than I had with going back to the grand jury. You just have your client sign off on it. Listen, that didn't work, but it was a really good trial strategy in the absence of any other trial strategy. A definition of a good trial strategy is anything better than none, okay? If you have no trial strategy, then you're hoping that they're really going to screw up, like the cop is going to get sick that day or something. So just an idea.
Here's the definition of knowing. A person acts knowingly with respect to the nature of his conduct or the intended circumstances, and you have both at play here, if he's aware that his conduct is of that nature, meaning I know I'm driving a car, or that such circumstances exist, or he's aware of a high probability of their existence. So he would have to be, basically, they'd have to know that he's driving a car, he'd have to know he's on the revoked list, he'd have to know he's on the revoked list for drunk driving, he'd have to know that it would be a second offense if it's dealing with a first offender under subsection A. So, I mean, these are all issues, and Joe, I guess they had knowing throughout all the jury charge, right?
They did. In 3 separate times they had knowing, and they said, nah.
All right. Now, if you go back and then substitute knowing in under E and F, this is subsection A. Remember, you have to drive on the revoked list twice during a suspension for a first DWI. You have to know you're operating a motor vehicle, know that it was during a period of suspension or revocation for 39-340, know that it was imposed for first offense DWI or refusal, and have a prior conviction for 39-340 directed to the same first offense. That's a whole lot to know. Under subsection B, it's a little bit easier because you only have to be caught once. Know you're driving a car. Know that you were driving during a period of suspension or revocation in violation of driving on the revoked list 39-340, and that had been imposed for a second or subsequent DWI or refusal. Okay? All right, guys, we got to get into some complicated stuff now. So let me kind of go through this step by step. The Perry case, which you heard so much about, and we'll discuss momentarily in a little bit greater detail, has triggered a whole bunch of unintended consequences. So let's go through them. At some point, some court of appellate authority is going to have to construe the holding in Perry with State versus Cucurello. Now, Cucurello is a 1988 appellate division case, a pure driving on the revoked list case. Here's the basic facts. The guy goes into court, pleads guilty to drunk driving, and pleads guilty to leaving the scene of an accident. Okay, he gets 2 suspensions: 6 months for the leaving the scene, 6 months for the DWI. All right. A couple days later, the cops grab him driving, and they charge him with driving on the revoked list. And now the issue is whether or not he's going to get the enhancements under 39-340. Defendant's argument is, hey, I wasn't on the revoked list for drunk driving. I was on the revoked list for leaving the scene of an accident. My DWI suspension doesn't start to run for 6 months. Okay. Joey, can you read the holding of the court here, where it says defendant?
Sure. Defendant contends that the legislature did not intend that a person receiving a DWI driver's license suspension be subject to the enhanced penalties of the driving while suspended statute for a period longer than the DWI period of suspension. I'm going to read that again because that's an extremely complicated. I used the word intend twice. Let me read it again. Defendant contends that the legislature did not intend that a person receiving a DWI driver's license suspension, convicted of DWI, judge suspends his license, be subject to the enhanced penalties of the revoked statute for a period longer than the DWI period of suspension. That is, the judge gives him 7 months. That suspension is only 7 months, and thereafter, if it remains suspended, that's for some other reason. The defendant argues from that premise that his exposure to enhanced penalties may not begin before the DWI suspension period begins. In other words, his DWI suspension was set to begin at the end of his suspension for another matter. It was a future suspension. We reject the premise. There is no evidence of such legislative intent in the language of either the DWI or the revoked list statute, nor would such intent be consistent with the legislative policies those statutes advance.
Now, a couple things you need to know about. Number one, this is a pure 39340 statute. The 2C40-26 was decades into the future when this came about. But yet, it is, in a certain sense, inconsistent with Perry. There's language which I don't have on the board, but I want you to all be aware of it, that the appellate division says you are under suspension for drunk driving from the minute your suspensions begin in municipal court. So if you have a bunch of incidents arising out of a single transaction and the judge imposes 2 or 3 suspensions, including a drunk driving, you're under suspension for drunk driving from the minute your suspensions begin.
The statute says that. The statute says the suspension must begin that day. That's what the drunk driving statute says. It must begin that day. So when the judge says, I find you guilty and I sentence you to blank, your suspension begins that day by virtue of the drunk driving statute.
But the key for all of you to understand, and this is why this has to be harmonized with Perry at some point, is that the determinate term of the drunk driving suspension is artificially extended because of these other suspensions that are imposed simultaneously. Everybody got that? So the window of this guy's suspension was not 6 months. It was a year. Okay? The judge considered the appellate division considered his driving on the revoked list during the period of suspension for his leaving the scene of an action to be covered under the drunk driving. So the determinate term for him, that his jeopardy basically was a year as opposed to 6 months. Now this is stuff that's done on the front end. Okay? These are simultaneous convictions on the front end. So far so good? Let's go back and talk about Zalta for a second, which Joe had mentioned earlier on. Zalta 1987, I think. And Zalta stands for this proposition. When the judge places you on the revoked list for a determinate term, you stay on the revoked list forever. You're on there forever. You can't get off the revoked list until you take the correct administrative steps to have the what is now the Chief Commissioner of the Motor Vehicle Commission restore you. Okay? So what does that mean? It means pay your restoration fee, get the ignition interlock device installed, pay your surcharges, go to the IDRC, whatever else they have you do. There's 50,000 other things you got to do. Remember, there's only one human being that can restore your driving privileges in New Jersey. And that's I forget they call him the Chief Administrator or Chief Commissioner or something. I think it's Chief Administrator of the Motor Vehicle Commission. That's the only person that can give your license back. Even the judge can't restore your driver's license. It's the Chief Administrator is the only person that can do that. So now the question became, all right, that's fine. Everybody understands that your suspension continues indefinitely. And oh, by the way, I'm choosing my words here very carefully. When I say restore your driving privileges, that doesn't necessarily mean anybody's going to hand you a driver's license, okay? Let me give you 2 examples of what I'm talking about. Nelson, the first one's for you. You've got plenty of people who come here from Honduras. They have no right to be in the United States. They get found guilty of drunk driving. You represent them very brilliantly. They get 3-month suspensions, total miscarriage of justice. They serve out their suspensions. They pay their restoration fee. They do everything they're supposed to do, and they present all the motor vehicles, and motor vehicles restores their driving privileges, okay? Except they don't have a driver's license, and they can't get a driver's license because they're not lawfully in the United States.
But suspend something that you don't have.
Right. I mean, their privileges are restored, but they still can't drive. They're just not on the revoked list anymore. But they don't have privileges to drive in the United States. They can't get a license because they're not here lawfully. Another example would be somebody who he's been out on warrant for 5 years or 6 years, finally decides he's going to straighten his life out, pays his fines, does everything he has to do, gets himself restored, but he still doesn't have a license because if your license has been expired for 4 years or more, you have to take the test again, the driving test, the written test. So again, this is a person whose privileges are restored, but he's not a licensed driver because he has to sit for the test again. All right, so there's a distinction there. It doesn't necessarily mean they've handed you a driver's license. So Zalta was very well established as law in New Jersey at the time that the 2C40-26 went into effect. There was an opinion in the appellate division, unpublished, called State v. Panico, which we'll talk about momentarily. And the Attorney General bootstrapped 2C40-26 to say, based on this Panico, that if you drive during a period of suspension that is related to the drunk driving, it has its roots in the drunk driving, so to speak, that would give you liability under 2C40-26, okay? So, for example, let's say the guy served a 2-year suspension and he just doesn't get his license restored because he doesn't go to the IDRC or something like that. In other words, his suspension is continuing, and it continues because it's related back to his 2-year suspension for drunk driving. If he drove during that time period one time under the Panico version, he would be subject to indictment under 2C46, 2C40-26B, because they would attribute that to being his second offense. Okay? Everybody with me so far? All right. Perry has changed the landscape on this, and here's Perry. Joey, could you read this to everybody, please?
The revoked list criminal statute makes driving while suspended a 4th-degree criminal offense punishable by a mandatory jail term of 180 days under certain circumstances stemming from driving while intoxicated. Now, driving while intoxicated, 39:4-50. Or refusal to submit to chemical testing, 450.4a. In these 7 appeals, consolidated for decision, we address, not way more than 7 points here.
Those are the future defendants.
In these 7 appeals, consolidated for decision, we address whether charges can be brought under the statute when the act of driving occurs beyond the determinate. That means the judge says 7 months. 7 months is the determinate term. Under the determinate sentenced term of suspension. But before reinstatement, the twilight zone in between the ending of those 7 months and when you actually take all the actions necessary to get your license restored, while the driver continues on administrative suspension. Why are you suspended? Administratively, you haven't met one of their requirements. You haven't shown identification, you haven't paid your restoration fee, whatever it may be. That's the administrative suspension. We conclude that the statute criminalizes the operation of a motor vehicle only while the operator is serving the court-imposed term of suspension and not thereafter.
Everybody cool with this? And everybody understand the distinction on Cucurella? Because Cucurella, remember, the guy's going to get more than the determinate term, and it may be that they're going to extend the determinate term based upon these other suspensions. We'll just have to see how another panel of the appellate division harmonizes this. Now, you should know, it's funny, there's a young fellow down at the shore who was, he views himself as a big-time attorney on drunk driving cases, and I talked to him about this when the case came out, and he said, I got the same issue in the appellate division right now. And I said, schmuck, get down there immediately and get that case out of there. Just withdraw your appeal. What are you trying to do, kill us? I mean, that's all we need is some other panel of the appellate division to come in and, screw us up on this. But I have been told that the Burlington County Prosecutor's Office, the Middlesex County Prosecutor's Office, and the Attorney General are all working to get this matter before the Supreme Court. And this is typical of the case, a case that the court would be interested in because the statute has never been construed by them at all. They like to have the first and final word on these important issues. So for today, this is what the law is. Whether it's going to remain this way, that's an open question at this point. Okay? But everybody okay with the proposition on Perry at this point? Okay. Now let's just do a little exercise now on just some of these permutations. Could you guys make one change in your notes? There's a typo here. See this 3 at the bottom here? Could you change it to a 5 in your notes, please? It'll make more sense that way.
One of my clients did on the chat.
She changed the 1 to a 9. All right. So first offense, the guy gets found guilty on 1/7/13, 7-month suspension. It ends 210 days later on August the 8th. Then the defendant gets caught here for driving on the revoked. He's still suspended, and then a second time here. Now, pre-Perry, this would have given him liability under 2C40-26A because he would have 2 driving on the revoked lists which were related, kind of go back. They have their roots in this suspension here. Now he would not have any liability under 2C40-26A. Question, Dr. Rem. This guy comes to you right here. Always been charged with this driving on the revoked list. Okay? Would you argue that the Perry case also impacts 39-340 in the sense that he is not subject to all the statutory enhancements under 39-340 for drunk driving because the driving took place outside the determined term of the suspension?
In this case, the guy gets his license suspended, his term ends, and then within a month, 5 weeks later, he gets a 340. All right. Now, Perry, of course, you're going to argue because you know
It's outside the determined term.
right, with outside the determinate term, so you're going to argue Perry.
But no, my question is, forget about Perry. Nobody's going to charge this guy criminally. He's got a ticket. And they want to lock your guy up between 10 and 90 days. And my question is, would you argue that Perry also impacts on 39340 because the driving conduct took place outside the determined term of the suspension? 2C40-26 is driving on the revoked list, okay? So it applies with equal force to the 39340. Those enhancements don't apply.
Yeah, I think obviously we're going to argue that because we don't want our client to get the 90 days or at least 10 days. And they're going to say, it's going to say Zalta, and you're going to say Perry, but you may have the trump card because you're going to say, listen, when Perry was decided, they knew about Zalta. I mean, it's been part of our case law for a quarter of a century. They knew about Zalta and still ruled that there's a determinate suspension, and when there's a statute, remember, criminal and quasi-criminal statutes have to be construed strictly in favor of the defendant. You know, a tie goes to the runner, and the defendant is the runner, kind of logic in baseball. That in this case, where there is a criminalization, where people are looking at losing their liberty, you strictly construe the statute. He was not driving while on the suspended list for a DWI at that time, and therefore the reasoning of Perry applies, and the way we interpret the statute, that is, in a very lenient way when it can be interpreted either way with respect to a defendant, must apply. So, yeah, I think Perry has to apply, although interestingly, Perry never references Zalta.
No. I mean, it's a pure 2C40-26 case, but again, as I indicated, 2C40-26 and driving on the revoked list are exactly the same thing. Here's our second example. Again, a 7-month suspension occurring in January. He gets a 39,340 here. Now, question. Remember, if this 7-month suspension here occurred as a result of a step down, the argument could be made by the prosecutor that this is enough because he's on the revoked list as a result of a second or subsequent offense, okay? So it's not enough to see that he has a 7-month suspension here. You'd have to inquire further to see whether or not it's a true first offense or it comes about as a result of a step down. And I'm assuming that the prosecutors will ignore the step down and treat it as a second offense for what it is. And it is a second offense. It's just for sentencing purposes, you're treated as a first offender. He gets stopped a second time again. He's still during the 7-month window here twice. So this is going to give him criminal liability under subsection A. Again, he has 2 driving on the revoked list within the window of this. One would be enough if this came about as a result of a step down. Now, this is a second offender. He gets grabbed here a couple months after he gets convicted. So this should be enough for him now, since he's a second or subsequent offender for either drunk driving or driving on the revoked list. The term ends here. He gets stopped here again. He would not have any criminal liability here under Perry because he's outside that window. But again, you have the argument as to whether or not he should be receiving enhanced 39,340 penalties because he's got stopped outside of the determined term of the suspension. Okay. Now, here is Panico, and a couple things you need to think about for Panico. Panico, first of all, was not published to begin with. I'm going to argue to all of you that Perry, the published appellate division decision, abrogates Panico. All right, Joey, could you read this? And
yeah, I got to tell you, the logic of Panico is really convoluted and confusing. So hang in there. Applying our reason in Zalta here, Zalta said that once your license is suspended, let's say for DWI, it remains that way for eternity until such time as you restore your license. Way beyond the 6 months or 7 months or 2 years, whatever it is, until you get it restored, you're still on for the original purpose of the suspension. Applying our reason in Zalta here, the source of the MVC's authority to continue defendant's license suspension beyond the 7-month period imposed by the court, which the other decision Perry calls the determinate sentence, that is, your license is suspended for 7 months. After that, it's just administrative. So that's the 7-month period of suspension imposed by the court was defendant's non-compliance with the statutory requirement to participate in the IDRC program by virtue of her conviction for the refusal offense. So she served her time, but she never went to IDRC. The requirement that defendant participate in the IDRC program is statutorily linked to defendant's refusal conviction. Sure, it arose as a consequence of her refusal conviction. Thus, whether the most recent charge for driving while on the revoked list arose out of defendant's failure to pay the requisite restoration fee or from the continuation of the revocation by motor vehicle for the IDRC violation, is of no consequence. The basis for the part of the sentence requiring her to participate in the IDRC program finds its roots in the refusal conviction.
Now, guys, this is a pure 39340 case, okay? It had nothing to do with 2C40-26. I'm not even sure the 2C4-26 was in play at this point. However, the position I'm going to suggest is probably the correct version of the law is that this has now been abrogated as a result of the Perry decision, okay? And is not good law anymore, all right? Okay. Now let's just talk about the enhancements for 39340 because there's a lot at stake here. There are 4 levels of enhancements when a guy gets stopped for driving on the revoked list as a result of a DWI. Now, let's go through them. You have the normal penalties A through E under 39340A through 39340E. And A, B, and C are really a function of how many times the guy's been caught by the cops before. So the base penalties, it's a $500 fine. You lose your license between 1 day and 6 months for first offense. Second offense is 1 day to 5 days in jail, $750 fine, and you lose your license again between 1 day and 6 months. Third offense is 10 days in jail, $1,000 fine, 1 day to 6 months. Okay? That's easy. If you're involved in an accident, this is subsection E, and somebody's injured other than the driver without regard to fault, minimum 45 days in jail up to 6 months. Okay? So those are the normal base penalties that any idiot would get. There is a requirement under subsection A that if you're on the revoke list as a result of a drunk driving, that in addition to any suspension you also get a suspension of registration privileges. Now, the suspension of registration privileges under subsection A is for the same amount of time that you would get for your license suspension. So if the judge takes your license for 6 months, you'd also get a 6-month suspension of registration privileges. Interestingly, this enhancement is only under subsection A. The legislature did not include it under B and C, which is just, I don't know if it's an oversight or just sloppy draftsmanship or something. I don't know. I've seen judges come down on both sides of it, one saying it's just an oversight and the legislature could not possibly have meant to exclude this for second and third offenders. Then I've had other judges who follow the rule of lenity that Joe was talking about a moment ago and say, listen, it's not in B or C, that you're not going to get it. But here is the enhancement. So for a first offense, you get the $500, and if that offense involves operation during the period of suspension for $450 or refusal, revocation of the violator's motor vehicle registration. Okay, so that's the second level of enhancement is registration. The third level of enhancement is under F2, which you're all familiar with now, which calls for an additional $500 fine, an additional suspension of 1 to 2 years, and a jail term mandatory between 10 and 90 days. That's under F2.
Now, you can think of it as F2, but given the extended driver's license revocation in the jail, you can also think of it as section FU, because that's really what it is to a defendant. Now, the fourth level of enhancement, and again, remember, these are cumulative. You add each one on. They're all in addition to each other. The fourth level of enhancement deals with driving on the revoked list as a result of a drunk driving if you're in a school zone, so within 1,000 feet of a school or driving through a designated school crossing, okay? And you can see that this, again, comes in addition to anything you get to A through E, which is the base penalties, and forget about one. One deals with driving without liability insurance. And you get it in addition to number 2, which is here, okay? And it's the same thing again. Another suspension of between 1 and 2 years, another $500 fine, and then jail, depending upon whether this is your first, second, or third or subsequent offense for driving on the revoked list in a school zone. You'd really have to be a cop magnet to get caught 3 times driving on the revoked list as a result of a drunk driving in a school zone. But this last one is more theoretical than real, but it's out there, and again, it's cumulative. So this is what's at stake when you have somebody who's driving on the revoked list as a result of a DWI, and if you're a defense attorney, you're certainly going to want to make the argument that Perry would apply with equal force to 39340F as it does to the 2C40-26. Again, this is advocacy. Let's see how these cases get decided as we argue in real time. Let me tell you about another point of advocacy. Here's why I think Perry has to apply, although I can already think of an exception to this. Here's why Perry has to apply to the motor vehicle. When you get charged with the indictable offense of driving on the revoked list due to a DWI, oftentimes, almost always, they're going to write you a motor vehicle ticket for that exact same offense, okay? So if you go to trial, the jury is going to decide the criminal offense of, let's assume you had 2 prior DWIs, whether or not you had 2 prior DWIs and whether you were driving on the revoked list due to one of them. Now, the judge, outside the presence of the jury, is going to listen to the testimony, and he's going to make a separate decision of whether you're guilty on 39-340. That's the way you handle motor vehicle tickets that arise from these situations. The jury hears the criminal charges, the judge silently listens to the testimony and is deciding the motor vehicle tickets. Can you imagine where there would be separate rules for the jury and the judge as to whether or not he was on the revoked list? That would be inconsistent. I mean, how would you explain that under our jurisprudence, that just depending on the level of the offense, that different rules apply, different rules interpreting statutes that have identical language? So I believe that that's a strong argument that Perry applies right down the roster of offenses that we have, because it would be inconceivable that one rule would apply for the indictable, but the exact same wording would have a different interpretation if it's just a motor vehicle offense. And of course, as I'm saying that, I am thinking of the fact that if you're charged with, let's say, vehicular manslaughter, because you were drunk and you were driving and you hit someone and you killed them, and they also charge you with a regular DWI as well as vehicular manslaughter. Here's the crazy part: there is a distinction. In the indictable offense, you can bring in a doctor and he can testify, although at the time they tested your blood, it was this. At the time you were driving, you were under the limit. You weren't really drunk when you were driving, because if you extrapolate out, the alcohol had not yet affected your system, and therefore you weren't drunk when you struck and killed that person, but within the next hour your blood alcohol rose to the point where when it was measured you were over the limit. Now the interesting thing there is, in the criminal case, the jury can consider extrapolation and say, yeah, we know that he was a .09 when he was arrested, but according to this doctor, Dr. Brick, he was only a .07 when he was driving, therefore he was not technically drunk. The judge deciding the DWI cannot consider extrapolation, just says, look, at the time you had a reading, it was a .09, you're guilty of DWI. So I'm going to give you both sides of it. That's the argument both ways.
Is this a great state or what? All right. Judge Sheplo brought up this ethical issue, and I want to kind of talk about it for a few seconds, okay? This is just another one of the unintended consequences of Perry. All right. What's going to happen is this. The cops are going to be locking up people all over the place, and it's easy for the police to tell that a guy's on the revoked list, all right? They're going to know. They might even be able to figure out that the guy's on the revoked list for drunk driving. All right? Maybe. But they're not going to be able to tell from looking at a certified abstract whether or not the guy's on the revoked list during the determinate term of the drunk driving suspension, which is what's required under Perry to charge the guy. Because the abstract doesn't give that information. I couldn't even tell by looking at it. I mean, the only way to really know is to, look up in ATS or ACS, whatever it is, what the sentence called for. For example, let's say that I look on the abstract and I see an O code for January. Is he on the revoked list as a result of the drunk driving? Well, I don't know. He could have gotten a 3-month suspension. He could have gotten a 7-month suspension. He could have gotten an 8, 1, 9, 10, 11, 12. Who knows what he got? You can't tell from looking at the abstract. All I know is he had a drunk driving at some point, and now he's on the revoked list. That's all I know. That's not enough to charge the 2C40-26. What I think is going to happen until administratively that the Motor Vehicle Commission and law enforcement can kind of work this out is you're going to see an enormous number of 39-340 tickets written without the companion criminal matter being charged. Okay? This is what I'm anticipating.
It happened in my case. He got the motor vehicle tickets. 3 days later, call him up and say, could you come back in? We got one more for you. And that was the indictable.
It puts you as a defense attorney in an extremely uncomfortable position, all right? Because you say to yourself, okay, I want to get into court and plead guilty fast before the cops figure this out, because by pleading guilty, I'm going to establish a double jeopardy defense for my client from being indicted and prosecuted on the 2C40-26, all right? But what ethical issues does that raise for you? Now, if you guys will indulge me for 1 second, I'll tell you a little personal war story that I had. I had a client who was a third offender DWI guy, and the cops never figured out that he was on the revoked list for drunk driving. And it was a difficult drunk driving case, and the court where this occurred, just like you, Kevin, I've been the public defender there for 25 years, and these people are my friends, okay? I mean, they trust me. They're not only social friends, but they're colleagues, and I have very, very deep feelings for them and vice versa. Because that's the way it is with the people you work with every day for years. That's just the way people are, you know? So, and I thought to myself, wow, if I plead my guy guilty now, I'm going to be helping my guy out, but if they never got back and these people got in trouble, the judge got in trouble, the prosecutor got in trouble, I mean, they would be so hurt that I did that to them. And I'm saying, am I subordinating my feelings for my colleagues to the best interest of my client? So I wrestled with it, and I finally sat down with my client, and I said, look, you got kind of a tough case here. I'd like to get your case moved from this court to the one court in the United States that's totally ill-equipped to deal with it, Superior Court, okay? So, am I making that up?
When in Superior Court, a speeding, I don't know how to handle it. Do you know how to handle it? Get a municipal prosecutor up here. We don't know what we're doing. Really, it's like you walking into patent court, or if there is such a thing.
I said to my client, listen, I'm going to ask the cops to charge you. They're going to do it on a summons. Don't worry about it. I'll take care of it in Superior Court. Nothing's going to happen to you, all right? Now, between you and me, I had no idea what I was going to do. I was just saying this to the guy to make him feel better. And in the end, it turned out okay. We got rid of it. It had nothing to do with me, by the way. It was just dumb luck that the indictable offense went away. But it bothered me and bothered me and bothered me. And part of the problem was, as I thought back about it, I was involved as a defense counsel in the N.J.S.A case, which I want to talk to you guys about for a second. And I think I overanalyzed the whole issue. I was really worried and not sure about what my obligation was under RPC 3.385. In other words, I wasn't sure whether I had an obligation to affirmatively reveal to the judge the possibility of the police charging my guy with the indictable offense, or to reveal it to the prosecutor. Would I be guilty of a violation of RPC 3.385 by not telling the judge this? Now, I want to spend a couple seconds talking about sealing, if you guys are okay. I just want to make sure it's necessary. Are you guys familiar with the sealing decision?
N.J.S.A.
You guys know about it? No.
This is an extraordinary case.
Can we spend 2 minutes talking about sealing?
It's important because it bumps its head up all the time, and so many decisions I have to make during the course of my day in terms of criminal cases and municipal motor vehicle cases. This case haunts me. It comes back in. It sneaks in, and you have to decide what your ethical obligations are, not only to the state, but also your constitutional obligation to your client to give him effective representation of counsel, and where these two worlds collide.
Okay. It's New Year's Eve. Two young people, 18-year-old fellow, beautiful 17-year-old girl are out on a New Year's Eve date. While they're traveling to the party they're going to go to, the vehicle they're in breaks down. The young fellow asks the woman to get behind the wheel while he goes behind it and pushes the car, it's our own country road, to get it off the road. While he's doing that, a vehicle driven at an extremely high rate of speed approaches them from the rear. The driver of the vehicle is a guy by the name of Poje, P-O-J-E. He proceeds to smash into the rear of the car, hitting it directly where the young boy is pushing it, killing him instantly and fatally wounding her. She dies a couple days later. The car that driven by Poje is blasted to smithereens. Poje, of course, is not hurt at all, jumps out of the vehicle and leaves, takes off through a field, leaving footprints. Now, even by Ewing Township standards, this was an easy case for them to track down, okay? They were able to, figure out who the driver of the car was, follow through the footprints in the snow. They got a warrant for his arrest, charging him with aggravated assault and aggravated manslaughter. Went to his house, knocked on the door. He's highly intoxicated in the house, but he's been out of pocket too long for the police to charge him with drunk driving. So they charge him with aggravated manslaughter, as I say, plus aggravated assault. They bring him to municipal court where the judge arraigns him. The Superior Court judge sets the bail, and they send him to the county jail. The young girl dies a couple days later, and they upgrade the aggravated assault to aggravated manslaughter, charge him again, bring him back, increase the bail again, because now he's got 2 counts of aggravated manslaughter, and away he goes to the county jail on very high bail. Now, aggravated manslaughter is a first-degree plus crime, which has a range of anywhere from 10 to 30 years, and the Supreme Court, through the case law, has no problem with people serving consecutive time when there's multiple homicides coming out of one single accident, especially a traffic accident. So essentially, this guy was looking at doing 60 years in jail. The bad news is these are near offenses, so he'd have to serve 85% before he'd be parole eligible. Now, if that was just the way things happen, that would have been the end of the case, and it would have gone through the normal way. Unfortunately, the police in this instance violated directive number 1 from the county prosecutor's office. They decided to think. Okay? Always very dangerous when police start thinking. And here's what they're thinking. About a month ago, we charged this guy with those double homicides, and we haven't written him a ticket yet for reckless driving. If we don't charge him with reckless driving pretty soon, the statute's going to run. He won't get any motor vehicle points out of this. Okay?
So he'll be able to drive at the prison.
Yeah. If he escapes, he'll be able to
want that to happen.
So the cops write 2 tickets without calling the prosecutor's office. They just do this on their own and write reckless driving and driving on the revoked list, okay? Excuse me, not driving, leaving the scene of an accident. 2 tickets, okay? Here's the 2 tickets. They take them, sign them, put them in an envelope, send to the defendant's home address. A few days later, the family gets this envelope in the mail. They open it up. They see these 2 tickets, and they call up GSCLE, who is representing him on the indictables. Jack, by the way, a certified criminal trial attorney, just like Joe. Family says, Jack, what are these tickets? And Jack says, you know what those tickets are? They're an opportunity. That's what they are. So he picks up the phone. He calls the court administrator, and he says, listen, my guy just got these tickets. He's got to be arraigned. Can you bring him over from the county jail to have a first appearance? So she says, yeah, sure, why not? So she gets a writ to bring him in. This is before they had television to do these things through the television. And it's a night session. They bring him there. Jack shows up on the appointed day, sees the prosecutor out in the hallway cutting deals with the pro se litigants. They exchange pleasantries, and the prosecutor says, Jack, you need me? No, it's just going to be a plea, no problem. So Jack goes inside. And they have the transcript of what happened in the courtroom in the opinion, and the judge calls the case, and the first words out of Jack's mouth are, guilty, Your Honor. Not hello, goodbye, good evening, Your Honor. The court, guilty.
How you feeling today? Guilty. How's the family? Guilty. Let's just...
Now, Jack was able to do this because he had been practicing this court for many decades. He knew the judge. He knew everything about the judge. And he knew the judge was obsessed with one thing and one thing only when he got to municipal court, and that was leaving. Okay? He just was obsessed with getting out of court and getting back to his private law practice, which he did. I think he did insurance defense work. He had a very successful practice. And he's a very nice guy, don't get me wrong. He'd say State versus Coruscant, and he would start arraigning the guy. Guy gets out of the chair. By the time he gets from his seat up to the bench, he's already done arraigning him, okay? And you couldn't understand what he said because he spoke so quickly, Not a mean man or unfair man by any stretch of the imagination, but just wanted to get the session over with so he could leave. And Jack knew this. The judge freely admitted that this was his philosophy, and his thought was, listen, if one case in 1,000 gets overturned on appeal, it's just the cost of doing business. Knowing that, Jack says guilty, and the judge immediately starts to sentence the defendant on the reckless driving. Gives him a $200 fine and all the appropriate stuff. Then the judge turns to the leaving the scene of an accident and says to Jack, okay, is this a personal injury or property damage? Personal injury, Your Honor. Now, the judge wasn't asking whether anybody got hurt because the judge didn't care. What he wanted to know is what section of the statute do I sentence the guy under, okay? Sentences him under A. Now, for the first time, the judge notices he's got a guy just dressed in a yellow jumpsuit with chains on from head to foot in front of him.
And that was Selig. You meant what the client looked like.
The judge says, are we going to be in for a while? Translation, how's the fine going to be paid? Okay, see, Jack knows what this is really all about. So Jack says, well, we're not sure yet, but it's okay. The family's here. They're going to pay the fine tonight. So the judge says, okay, sounds good to me. Go out to the violations window. Everybody have a nice life. And that's the end of it, okay? Now, for those of you who are playing along at home, you see exactly what Jack is doing here. He's setting up a Dively defense, having his client plead guilty to an offense that has recklessness as an element to bar the state from prosecuting him on these two aggravated manslaughters arising out of the same incident.
Conduct.
Everybody got that? So, the judge was bothered by this because he said there was just something that was bothering him about it. You know, he thought about it all night long, came to work the next day, spoke to the court administrator, and said, you know, that guy was here last night with GSCLE. Where have I seen that guy before? How do I know him? And she said, well, Judge, that's the guy you arraigned last month twice for aggravated manslaughter, you know. Now, it's not like they have murderers coming into court. This is not Trenton Municipal Court. They don't have that many homicide cases coming into Ewing Township for first appearances. So the judge says, ooh, I think I did a bad thing. So he got on the phone and called the prosecutor's office, and the 10-foot crater from the courthouse blowing up there is still, you can still see it to this day. The prosecutor's office is totally freaked out because they have this unspeakable catastrophe now they see going up in smoke, well, double jeopardy grounds. So after they calmed down initially, they got a hold of the transcript and filed a motion before the assignment judge to vacate the plea. They had two independent grounds, one so colossally retarded, I'm not even sure I want to tell you about it. The other one that actually made sense. The first one was, the one that was ridiculous, was that the state had been deprived of due process. Okay, it's advocacy, right? But the one that had legs was, they looked at the transcript and said, what guilty plea? This defendant never pled guilty. The judge never personally addressed him. The judge never got a waiver. The judge never advised him about the consequences of his plea. There was no knowing voluntary plea granted here. There was nothing. The lawyer pled guilty. All right? So the assignment judge gave the motion to the PJ of our vicinage, the functional equivalent of Judge McGady, who heard testimony on it and ultimately vacated the plea. That withstood a challenge both in law division and in the Superior Court on unpublished cases, which nobody wanted to have these things published because the whole thing is so embarrassing. And that should have been the end of the case, except the law division judge felt he was obligated under Rule 1:18 to report Jack's conduct to the Office of Attorney Ethics because he felt he had violated RPC 3.3A5, that he had not told the judge information which misled the court. He didn't tell the judge that there were these two open criminal complaints at this time charging this guy with aggravated manslaughter. So the battle is joined. They transfer the case to Burlington County, and it's a knockdown, drag-out trial with extremely important legal issues that were really kind of unprecedented. Jack's argument is, I am a certified criminal trial attorney, and I'm representing a client, my client, who's looking at going to jail for 60 years. The Supreme Court expects me as a certified criminal trial attorney to do everything in my power to zealously and lawfully represent my client, and that's exactly what I did here. I didn't invent State versus Dively. You did, okay? All I'm doing is taking advantage of the tools that were available to me. And oh, by the way, it's pretty lonely here being prosecuted for an ethics violation. Where's the prosecutor? If he'd been there doing his job, this wouldn't have happened. Where's the judge? If the judge had done his job and asked one simple question, this wouldn't have happened. Why am I being subject to being prosecuted for this when I was just doing my job as a defense attorney? Now, I have to tell you, his argument had legs. The District Ethics Committee refused to find that he had violated any RPC. It went to the DRB, and the DRB was split. They couldn't come to a decision either. Everybody can see the issues here. This is why SEAL became such an important case. Ultimately, the Supreme Court, in a decision written by Chief Justice Ports, determined that Jack had violated RPC 3.385. Notwithstanding your obligation to be a zealous advocate on behalf of your client, you also have a concomitant obligation to the fair administration of justice as a defense attorney. And Jack, in all honesty, should have told the judge about these pending complaints. They were not subject to any type of privilege. They were in the public domain, so to speak, and the judge was misled by not being told about them. However, notwithstanding that, they determined they were not going to discipline him, and there were two reasons for this. Number one, that he was acting in good faith. There was no venal motivation in doing this. He actually believed he was doing the best he could for his client. And number two, more importantly, the court had never construed 3.385 previously. So Jack would not have been on notice as to what the parameters of the rule and the limitations of the RPC were in New Jersey. So he was able to walk away from this without any public discipline, although in a companion, but there's a concurring opinion, I think it might have been written by Justice Revoked, where she accused him of all kinds of shady practices and sharp practices, and she was not happy with him at all. But the bottom line is that he walked away from it, although I'm thoroughly satisfied this took years off of his life, the stress associated with it. He died, by the way, just last December. His case has become of national importance. If you ever shepherdize it, you'll see there's been half a dozen law review articles written on it. It's been cited in every state in the United States because it deals with such an incredibly important issue for all of us. Now, let's get back to our situation with the 2C40-26. And I commend to you the Appellate Division decision of State versus Kane, which is going to provide us with some guidance. By the way, here's the citations for everything. There's the Dively citation. There is the citation on GSCLE right there. I used to call him 180 New Jersey 234, by the way, when I saw him on the street. That was his nickname to me. All right. Here is a definition of 3.385. A lawyer shall not knowingly, so remember, knowingly is the key here, fail to disclose to the tribunal a material fact, knowing the omission is reasonably certain to mislead the tribunal. Okay? Now, question. You know for a fact that your guy could be indicted for 2C40-26. The cops haven't figured it out yet, or for some reason the cops have made a decision to exercise their discretion and not charge your guy. Who knows what's motivating the cops? All you know is that by pleading your guy guilty, he's going to walk away from being indicted on the criminal matter. Okay? Question. Do you have an affirmative obligation to reveal this to the prosecutor and judge, or is your obligation as an advocate to sneak into court, don't even sneak, just walk right in,
Boldly go where no man has gone before.
and plead guilty fast before they figure it out? What do you guys think?
Well, there's a big difference between your client who's been charged and your client who might.
Kevin, let me...
I think that's the key distinction.
And I agree with you. I think if you go back to 3.385, you know that there is an active criminal complaint charging your guy. It's just not before the municipal court judge. Okay, it's up Superior Court somewhere. Okay, I think you have a GSCLE case then. I think you have an affirmative obligation to tell the judge. I agree with you 100%. I'm talking about something that's a little bit more nuanced. They haven't figured it out yet. At the end of the day, whatever nonsense the defense attorney and the prosecutor want to work out in terms of the case disposition, they can do whatever they want. But you're the final arbiter about whether or not a plea and sentence agreement is in the interest of justice. Now, if you see independently that this guy could have been charged with an indictable offense, and you say to yourself, listen, I'm not sure that this is in the interest of justice until either the county prosecutor or the municipal prosecutor has told me that they don't want to indict this file, and I'm not going to allow the plea to go forward, I don't know that anybody could legally complain about that. But have I framed the ethics issue under 3.385 sufficiently for everybody? Because I want to get into the Kane case now, and I just want everybody to be oriented because there's a lot of context going on here. Everybody cool?
Yeah, one of the differences between the two cases, as I see it, is that the Puzio and Pitcher kind of
mistake of law, mistake of fact.
Yeah, one was the GSCLE was a mistake of fact. That they didn't know that this guy had. The judge didn't realize that this guy had indictable convictions arising out of the same one. That's a mistake of fact. In this situation, you're talking more about a mistake of law, to the extent that you want to call it that way. They don't have to charge him. remember, that's the important thing here. In this kind of case, it's a charging distinction. I've had a lot of cases, I shouldn't say a lot, I've had a number of cases where my client clearly fits under the indictment, and the cops just decide to keep it in town, keep the, what they want, and just charge him that way. And they know that he has 2 DWI priors, and they know that he has a prior suspension and a prior DWI, and he's still on it. And they choose to just charge administratively. We cannot intrude into the executive branch's discretionary function as prosecutor. They decide what to. How many times do you, Judge, get back for handling as a disorderly persons offense a $15,000 bad check? Right? What's the limit under the statute? 200. Beyond 200 is an indictable, but you get back a $15,000 bad check because they just decided executively in their executive discretion where they want to have that matter handled. So if the authorities, the police and the police in the town decide, look, we're just going to keep this in a municipal court, they have the right to do that, and we have no obligation to intrude into their function as defense attorneys in particular. Say, well, guys, you could really kill him. Let me give you a list of other offenses you could charge him with on this. That's what that would be. Now the defendant has lost his right to effective assistance of counsel because his counsel is assisting, the state's getting the effective assistance of his counsel, but not the defendant. We are a separate branch. We need not intrude into their function. So I think it's more mistake of fact, like the court has no way of knowing this fact and that would affect them, as opposed to you guys should look at the abstract because neither one of you got the abstract, and there's another thing out here I'm not telling you about.
Think about all the things that go into the decision of the prosecutor, county prosecutor, when they're looking at these cases. I mean, this is why prosecutors are vested with such huge discretion. And one of the things the prosecutors look at is jury appeal. And I know this sounds ridiculous, but you got to think to yourself, I've got a shoplifting where the guy stole $202 worth of stuff, all right? Am I really going to indict a file for $202? What possible appeal does that have to a jury, okay? The guy will get speedier justice, faster, and more punishment in municipal court than he ever will in Superior Court, okay, on a case like that. I mean, these, among other factors, in terms of resources and things of that nature, are what's driving the prosecutor's office. They have their own justifications. By the same token, though, I agree with Joe. I think you don't have any obligation to tell them how to do their job, I guess is the best way to say it.
Yeah, listen, sometimes they charge my clients with vehicular manslaughter, but they could also charge them with aggravated manslaughter because the facts support both. One is a second-degree offense, one is a third-degree offense, huge difference. Do I have to tell them? There's more serious offenses you could have charged them with. Can I go into Superior Court, pleading guilty to a third-degree offense and get them probation? Sure I can, and that's my obligation. The fact that they choose not to exercise their discretion, I don't need to intrude and tell them how to do their job.
Now, let me just give you some background on Kane, all right? This has been to the appellate division twice. 2 opinions from the appellate division. Once there was a remand, then it came back. This is the second go-through. Both times unpublished, both times per curiam, which is not unusual. Per curiam decisions are almost always unpublished. The only common denominator between the 2 of them was Judge Sabatino. He sat on both panels. So I suspect that he wrote the opinion, both on the first time through and the second time through. The case has very convoluted facts, but it deals precisely with the legal issue we're talking about. Joey, could you read this to everybody?
Sure. To be sure, 2C40-26 was a relatively new statute in March of 2012, just maybe 6 months old, 7 months old at that time. And it is conceivable that the court and the municipal prosecutor may not have been well attuned to its potential application in DWI cases. In fact, really, when's the first time we started seeing these charges? Really, in the last year or two. They were out for, this statute existed for 2 years. No one was getting charged under it. And you talk to cops and municipal prosecutors, no one had any idea it existed. And that's the truth. Nevertheless, we reject the state's claim that defense counsel was obligated under the rules of professional conduct or other ethical rules to spotlight the state's potential application adverse to his client's interest. The situation here is markedly different from N.J.S.A, in which a defense attorney affirmatively misled a municipal judge about the facts in a vehicular case, i.e., whether the victims had died. As the municipal prosecutor honestly acknowledged here, it was his responsibility to be aware of of Title IIC's provisions potentially applicable and to refrain from participating in the entry of a guilty plea to a lesser charge that would have a double jeopardy implications for future prosecution for an indictable offense. The fact that the municipal prosecutor accepted that the original plea was his mistake and decided not to file an application or pursue means to have the plea vacated speaks volumes. There was no fraud or unethical behavior by the defense here. Instead, as Judge Wild aptly found, defendant's first attorney was deficient. Defendant's first attorney was deficient in advising her, the defendant was a female, advising her to withdraw the plea to her detriment without explaining to her the consequences of that course of action. Withdrawing the plea to the motor vehicle charge so that she would be exposed, and the attorney specifically advised her to withdraw the guilty plea to the municipal, to the motor vehicle code violation so that she would then become exposed to the indictable. That was her intention because she felt she had done an N.J.S.A, an action that was barred by N.J.S.A, and she would be ethically compromised and that her license of law might be on the line. So she wanted to undo that before anyone came looking for her. The ethics police kicked down her door one day. Instead, as Judge Wild aptly found, defendant's first attorney was deficient in advising her to withdraw the plea to her detriment without explaining to her the consequences of that course of action. Even giving all due respect to the court and cooperating with its request to have the case relisted, a proper advocate for defendant would have politely resisted the effort to have the plea withdrawn.
So here's the situation. This is an unpublished decision at this point. I have personally written to Judge Sabatino. I have urged other members of the defense bar who understand the ethical implications here and the guidance that this case gives us for these types of situations, also to write to Judge Sabatino to persuade him to have this case published. Remember, in the appellate division, the judges decide for themselves whether a case is going to be published. I thought, and I mentioned to Judge Sabatino, that I thought that the case had the requisite amount of scholarship associated with it, but more importantly, it deals with a burgeoning problem that's going to continue unabated in light of the publication of Perry and the deficiency in terms of how police are just not going to have this information readily available to them. And I anticipate that this will happen more and more and more in the future, and the defense bar, as well as prosecutors and judges, need guidance on the outside parameters of RPC 3.35. Joey, I'm just curious to see, do you think I'm out of line here, or do you think this is a...
No, listen, the appellate division has to, they make recommendations whether or not the decision be published, and they go by the standard, which is they ask themselves the question, does this help the state? If it helps the state, they urge that it be published. If it's pro-defense, then they ask that it be secretly destroyed and no reference ever be made to it by any person under pain of death. Bob is correct. There's Judge McGady for years advocated that it was Moran that be published because he said, look, judges don't have any guidance in how to sentence people to jail in municipal court for certain offenses. Here we have a case that really helps us. You've got to get it published. And so they ultimately...
Bendix, too? That was his...
Bendix, I'm sorry, Bendix, not Moran. Bendix and the Diner case. No. That was different. But the point is, this case is really critical because there is nothing worse as a defense attorney than to have to decide, I have to make a decision here. If I decide this way, that might be contrary to the rules of ethics. It might be, I don't know. But if I decide this way, it might be contrary to my obligation under the Constitution to effectively represent my client. Now, which do I want to violate, the Constitution or the rules of ethics? You should never be put in that position where, no matter which way you turn, your license to practice law, your integrity, and the tradition of jurisprudence in this country is going to be endangered. You shouldn't be in that position. So when someone finally comes down and says, look it, this is going to happen a lot, as Bob said, this is going to happen a lot. Countless thousands of attorneys will have guidance. Judges will have guidance as to what the obligations of the parties are in a fixed situation and by extrapolation to similar situations. This case is critical to the proper administration of law and to attorneys across this state getting to sleep at night without worrying that their license to practice law is on the line, not because they're trying to do something that's wrong, but they're desperately trying to figure out which in these two competing factions is right.
Everybody cool with this then? You're all big guys. You can all make your own decisions. But I agree with Kevin Corsten that if there is a complaint written, you're obligated to tell the prosecutor and the judge that there is a pending complaint. If there isn't one written, then I think you're going to be pretty safe by trying to get your guy to plead guilty. I don't think you have an obligation to tell anybody. And finally, my opinion is that if the municipal court judge says, no, I don't find this to be in the interest of justice, until the county prosecutor has signed off on this, then I think you'll be okay too. It'd be like you get a ticket. There's personal injury, and the guy's charged with reckless driving. Okay, I don't know how you can take that plea until the prosecutor's office has looked at it to see whether they want to indict it. I mean, you can, but you know.
Yeah, I had a client of mine, a very lovely lady. The drive-through at Wendy's, but apparently there was no drive-through at Wendy's.
There was when she was.
She drove through Wendy's. She literally, it's not like she just, hit the front door. I saw the video just this week. She drove right in, fully in, and then was maneuvering. I mean, it just quickly went right through the whole thing. And sadly, some 88-year-old World War II decorated veteran who just was doing something as dangerous as being inside a fast food restaurant, trying to order a hamburger maybe, and he's dead. I mean, it was so tragic. And this woman is 77, and she's a registered nurse and still working. Her husband's a doctor, paragon in the community, no prior driving offenses. I mean, and now someone is dead. And in that case, they charged her with careless driving only. And then the prosecutor's office examined it to see if they wanted to do something. So I waited a requisite amount of time, and then I called him up. I said, listen, what do you think? And I said, oh, no, we're sending back down. He says, look, he says, sometimes stuff happens. He says, she wasn't reckless, She's 77. We suspect that she meant to step on the brake because she was just pulling up. She slowed and slowed and slowed. And just as she approached the curb, because it's a head-on into the store, just as she was approaching the curb, you'd think that's the point where she's going to step on the brake to bring it to a complete stop, and all of a sudden it accelerates in. She believes it may be unintended acceleration, but the likelihood is she put her foot down on the gas instead of the brake because he kept accelerating as it went into the store. Anyway, so they said, look, Joe, he says, just because someone dies doesn't mean it's a crime. He says, we looked at this. We had no problem right from the outset saying this wasn't recklessness. There clearly was no alcohol or drugs in this. This is a careless driving case. That's all it is. Go back down with it.
All right, guys. Now, I want to tell you a little story about State versus Sylvester. I was minding my own business. You got to understand that going in. So I said to myself, this is horrible. I'm going to look at something even worse than YouPorn. I'm going to read the unpublished decisions on the judiciary's website.
Judicial porn. Jew porn.
Right. So I get this Sylvester case. I'm starting to read it, and I'm reading this psychobabble from the appellate division. I'm saying to myself, well, you know what? I'm not going to get angry about it. It's an unpublished case. Who cares? Goodbye. Goodbye to you. And, I'll find a better website to go to later on. Don't you know 6 months later, some Schweinhund comes along and approves this for publication. And now we're stuck with it. All right? This horrible piece of garbage. Now, take a look at it. As Joe said, it's helpful to the state. Look at this. Defendant gets a 2-year suspension for drunk driving in 2011. Okay? The cops grab him driving in 2012 and charge him with a 2C40-26. Why is he driving? Because it sure beats walking. Okay? So the guy now goes to Joe and hires Joe Reb.
Well, actually, it was a guy named Joe who represented him.
All right. Joe goes back to Maywood, all right, and files post-conviction relief. Traditional out-and-out PCR. And by some miracle, Joe wins. The conviction's vacated. Ineffective assistance of counsel or no factual basis, whatever it was. But Joe Rem gets his petition granted. It's like a miracle, but it happens. So what does that mean legally? Well, the plea is vacated. The parties are returned to the status quo ante, and now you have a case that has to either be tried, pled out, dismissed. You got to deal with it. But the plea is vacated. All the stuff associated with the plea is vacated. I think theoretically the guy's entitled to get his money back, right? You agree?
Without question.
Okay. So what is the impact that has on his driving? You would think that his suspension for driving on the Revoked when he got caught here would just kind of just disappear up into the clouds, right, Joe?
That's correct. And when because of that PCR, remember, you got to remember that until he got the The second suspension, this is the one that was killing him, until he was driving on that suspension. That's what's killing him. But when you get the PCR and you look back, you say, okay, this was unconstitutional, or at the very least illegal, and now it no longer exists. The judges ruled this was unfair under the rules of court, and therefore it no longer exists. And you have to have said...
pick it up right here, Joey.
Yeah. The fact that a defendant is able to obtain post-conviction relief following a charge of N.J.S.A. 39:3-40 and 2C40-26 does not erase the fact that the defendant initially drove during a period of suspension. As the Supreme Court noted in Gandhi, and Gandhi is rolling over in his grave because of this. We insist on compliance with judicial orders to promote order and respect for the judicial process. Compliance is required under pain of penalty unless and until an individual is excused from the order's requirements. Thus, as long as a court order exists and a defendant has knowledge of it, defendant may be prosecuted for a violation thereof, regardless of its deficiencies.
Would you guys all please take out a pencil and circle this language right here? As long as a court order exists and the defendant has knowledge of it. Remember, we talked about this as a cross-reference to knowledge and the idea of being knowledgeable about why you're on the revoked list. Okay, this dicta here in Sylvester, in fact, I'm not even sure it's dicta, supports the position of requirement of knowledge about why you're on the revoked list in a 2C40-26 prosecution. Everybody see that? So if you're going to raise this argument, you cross references to this passage in the Sylvester case. Now, the problem with this when they decided to publish it was like I had this precise issue 2 days hence, in the prosecutor's office. But fortunately, I have a very good prosecutor's office. And my case was slightly different. Let me tell you the distinction of my case. My guy had gotten a suspension back in, 2002 or something, and got a 12-year suspension of his license. All right, and the cops grab him 8 years into the suspension. So I went back to court because I got a hold of the transcript and persuaded the judge that they had sentenced him illegally. It shouldn't have been 12 years. It should have been 4 years. He gave him a 10-year suspension and a 2-year suspension. And I pointed out the mistake. The judge says, oops, my bad. I'm going to resentence your guy. And he got a 4-year suspension, 2 and 2. All right. Well, my guy, when he drove, was well outside of that. And under Perry, he would have, should have been fine. So now the issue comes down, well, forget about that. What about this? He did drive on the revoked list, and there was an order at that time. And the prosecutor's office said, look, this is a different situation. Your PCR wasn't vacating any conviction. This was a mistake the judiciary made. I mean, it was the judge's mistake to put him on the revoked list. It wasn't anything that happened at the trial level. The judge it was just judicial, they didn't use the word incompetence, but oversight or mistake that put him there. And they felt that the equities balanced in favor of them treating him like a State versus Perry guy since he was outside the window of the suspension. So I don't know as a matter of equity that the appellate division would look at it differently if the PCR dealt with a mistaken sentence as opposed to vacating something under PCR. Do you have any thought on that, Joe?
Well, let me just explain to you. There's an interesting set of facts here, and this is the attorney. He's a Morristown attorney. I think it was Joe Trulin who did this. This is really clever. This is his second DWI, and he's driving while on suspension for that second DWI, okay? So Joe files a PCR on this second DWI. Obviously, that's heard after his arrest on the 2C40-26 charge, because that's the whole point. So he goes to the court and in futuro after this offense and says, this should be vacated. Now, you have to determine what happened, what was said. Just know that the judge said, I hereby, in PCR, he said, I agree with you, I grant the PCR, and this offense is now null and void. Joe said, it's null and void, thank you, Your Honor. My client pleads guilty to this offense, keep the fines, we're out of here. Pled him guilty 3 seconds after the judge vacated it. But now the conviction occurred over here and not over here. So, I'm sure there was no prior conferences. Don't worry, you get to keep the fines. He's going to lose his license. Well, there was no conference like that. It'll just, now that you vacated it, this horrible abuse of his rights, we plead him guilty to it again. So he was vacated. He was not convicted of it for about 10 seconds. I vacated. I plead guilty. Thank you. Same offense. This was great lawyering. They screwed it up, but it was great lawyering.
Everybody cool with Sylvester? All right. A couple quick things on plea and sentencing, because the law has changed here fairly significantly as a result of two appellate division decisions that are kind of related to each other. It's a fourth-degree crime. $10,000 is the maximum fine. The jail term is a 180-day parole disqualifier. And I want to talk about this real fast, because with this parole disqualifier, I can only think of one situation where you'd get any credit against a sentence. Joe, can you listen to me with half an ear on this? Because I want to make sure I don't make a misstatement of law.
And I've read some reports about this sentence, and I discussed this with the trial judge, and I know what other counties are doing, so.
Well, I'm just going to talk about credit. Just credit against a sentence. There's only two circumstances I can see where you would get jail credit for this. A, the judge, you try the case, you get found guilty, the judge revokes your bail and holds you while they're doing a PSI, and then it brings you back in 2 months and sentences you. The judge would give you credit for time served for the time you spent from the time you got convicted until the time you got sentenced. Or alternatively, you're out on bench warrant, the cops grab you, they throw you in the county jail, and you're held there in default of bail to either get tried or plead out. Again, the time you spend in jail attributable to the bench warrant on the 2C4-26, the rules of court would entitle you to credit for time served on that.
There's one other one. The police arrest you that day, and they give you a warrant. You're under arrest, that's 1 day of jail credit.
Okay. But apart from that, though, the commutation credit, good time credit, all those credits that you would normally be entitled to, none of that applies when you are serving a parole disqualifier. And that is new law. That's not new at all. It's been since the early 1980s, okay? I want to talk about French and Harris. Let's do French first. So here's the plea offer in French. It's a third offense DWI. Plead guilty to the 2C40-26, 6 months in jail on both to run concurrently. And then you get a dismissal of all the companion traffic tickets. So the guy pleads out, and then he goes to the judge after he gets sentenced and says, listen, I got accepted at an inpatient facility in Florida that's been approved by the N.J.S.A, and I'd like to do the last 90 days of my sentence in Florida. And the prosecutor's office objects, says, no, you got to do the whole thing in jail. And the defendant says, no, 39-450 says, I can do 90 days in a rehab facility. So you see the setup here. The appellate division says the following: the 450A3 allows the judge to authorize as much as 90 days credit against the mandatory 180-day jail term required for third offenders for time spent in an IDRC-approved inpatient rehabilitation facility. 2C40-26 requires a minimum jail term of 180 days, all of which must be served without parole eligibility. As a result, a defendant who's been sentenced to a concurrent 180-day jail term for both 2C4-26 and the DWA may not reduce any period of his incarceration by enrolling in an IDRC-approved drug or alcohol inpatient rehabilitation program. All right? All you get is jail and every day of it. Now, Harris had it's a series of 7 or 8 defendants cherry-picked by the Attorney General from around the state, and they all had 2 things in common. Number 1, they had all been found guilty of 2C40-26, and number 2, none of them was in jail. Rather, they all served these goofy programs, SLAP, home detention, they had a few more that I did, enforced community service, and a few more that I never heard of, okay? And this is like, creative lawyering to try to keep your clients from having alternative jail terms. Can you read that, Joey?
Sure. The legislature's purpose in requiring a mandatory period of imprisonment for this offense with no possibility of parole is also clear. Alternatives to jail, like the inpatient drug rehabilitation program involved in French, or the home detention and community service programs at issue here, do not protect the public in the same way as incarceration. The public safety consideration is especially relevant in the case of a defendant who loses his or her driving privileges for DWI, but then continues to drive despite the license suspension.
Now, AA, could you give me if it's available, the citation on State versus White, Judge Bowe's decision, please? I'm going to give you the bad news and the worst news, okay? When you read this case over, Harris, they construe the words "in the county jail," all right? right? Imprisonment in the county jail. You know what that means to them? It means being in the county jail, all right? It doesn't mean slap. It means when the legislature says in the county jail, they mean in the county jail. Well, the bad news is, 2C40-26 is 39340. It's the same thing. If you look at the 39340 statute under all the subsections, they say imprisonment in the county jail. So the argument that prosecutors could be making is, look, for 39340, since the legislature says in the county jail, that slap and all these alternatives on just a straight-out driving on the revoked list should not be available. There are two cases dealing with this issue. One is a law division case, published. State versus Duva is the name of it. The second one is a municipal court case published called State versus White. And White, written by our friend Judge Bowe up in Sussex County, stands for the proposition when you're on the revoked list for 39340 and the legislature says you go to jail, you go to jail. Slap and all these other alternatives are not appropriate for that. I just want to mention one thing real fast, guys. This Nazario, in my county, this was a big deal because the prosecutor's office, like in New York City, remember the old days used to have the pushers that would push people into the subway, to fill them up. That was what they were doing in drug court in my county. For all the people at the 2C40-26, they were just trying to rush them through drug court because they knew this case was in play and they were trying to get it all done because they knew that Daddy was going to take the keys to the T-Bird away, So up until Nazario got published, people were getting drug court in my county. Drug court is now off the table as well as a result of the Nazario case. It's not brought up in Harris or French, but I just want everybody to be aware that there's an unpublished appellate division case taking drug court away as an alternative, all right? Here's Grabowski and Kotzev, and Grabowski construes to be, let me see if I have it up here. I don't. It's to be 12-22 is the statute. Here it is. It says right here. A court may order that a sentence of imprisonment be served periodically on particular days, rather consecutively. The person in prison shall be given credit for each day or fraction of the day nearest the actual hour served. Now, Grabowski parallels precisely the argument Joe was mentioning before. When the legislature created mandatory jail for third offender DWI people in 2004, this statute was there. It was in play. Okay? Did they say in the statute, notwithstanding this, everybody's got to go to jail, or this statute doesn't apply to people who are third offense truck drivers? No. They never even brought it up. So Grabowski, this is a law division judge in Passaic County. Do you remember who it was?
Judge Delucia. His son was, you should know that his son was a police officer in California who was shot and seriously wounded on the job and had to retire. Mm-hmm. And he still renders decisions based on the facts and the law, and frequently when the law says that the tie goes to the defendant, he gives it to the defendant.
So in this particular case, the judge said, look, the statute's out there. The legislature didn't ban it. It says what it says, and this is an alternative you can use. You can get periodic service of imprisonment on a 6-month term for drunk driving. Now, Kotzev is what you're up against. Kotzev's an appellate division case and is very critical of Grabowski on policy grounds, all right? But notice that the appellate division does not disapprove it. They don't overturn it. And I think the reason for that is because they can't, because the judge is right on the law. But what he's saying is not open to dispute. It's just that the appellate division feels that it's more important that people be in jail for the entire sentence as opposed to being allowed to do portions of it as you go along. Joe, you going to make that pitch for your guy?
Yeah, I can tell you that the problem that I'm going to have in Bergen County is that some county jails around the state are following Grabowski and saying, look, you can serve it periodically. You can serve it on weekends until you're done. That's okay. Now, I called up Bergen County and said, what's your position? Said, no, 180 days. You go in day 1, you come out day 180, so your sentence is over in 180 days. Now, Judge Delucia and Grabowski went through the law and came out to that conclusion. As he points
State
out,
versus Hughes.
As Bob points out, that Kotze does not disapprove of it. Now, it's one thing to talk about policy, but it's another thing when policy runs smack dab into the face of clear, plain, and unambiguous language to the contrary. Now, it's my recollection that Judge McGady was tasked with reviewing Grabowski for Bergen County and deciding whether or not this was good law. I don't think the authorities in Bergen County were happy by people serving their mandatory terms of imprisonment. And my recollection is Judge McGady went back and said, I've looked at it. I've tried every which way. This is good law. It follows the law. Periodic service of these sentences is okay. Now, the Bergen County Jail told me, we don't care. We're not giving him periodic terms. If he's sentenced to that, we're not going to honor it. So this is going to bring me to a head on sentencing on my client.
Joey, can I help you out with that?
Yeah, go on.
What's the citation on the case, Doug?
You gotta give me a year because there's a lot of them.
Around 1996, something like that. Judge Pressler wrote the opinion. I commend to you, we'll have the cite for you in about 2 seconds, a case called State v. Hughes. It's a published appellate division case from Judge Pressler. And by the way, when you have a Judge Pressler case, you've really got to stress that over and over and over, because you're dealing with one of these giants in the history of the New Jersey judiciary.
She was the presiding judge for the appellate division.
Right.
And if you ever had the opportunity to appear in front of her, she was really good. I mean, she was very firm. If the state was right, she was firm in favor of the state. If the defense was right, she was very firm in favor of the defendant. She didn't have a horse in the race. She just wanted justice to be done. And what a wonderful woman.
Hold on for 1 second, because this case is going to be dispositive of the issue. All right? Here's the facts of the case. It's a Monmouth County case. So driving on the revoked list, their defense. Judge says, okay, 10 days. You're going to surrender in a week. Here's a copy of the commitment order. Show up in jail on a particular day. All right? So the defendant goes to the county jail, has a commitment order in his hand, knocks on the door. I'm here to start my sentence. The sheriff says, we're kind of crowded today. I tell you what,
reservation?
go home. We'll call you when we're ready for you. All right? So he leaves, and he doesn't hear from them for months. So, and this is hanging over his head. So he goes back to municipal court and says, my plea should be vacated because of cruel and unusual punishment and double jeopardy and all this. And I tried to get in the jail and they won't take me. Okay.
I can't do anything at work because I don't know when I'm going to be called in and go to jail again. My whole life is in flux because I don't know when I'm going to have to serve this term.
So that's the easy part of the case. Judge Pressler dismisses that. It's not a double jeopardy implication. She then spends 80% of the opinion saying the following. Listen, jails. Listen, sheriffs. When a judge of the municipal court signs an order directing that a defendant serve a term in a particular way, shape, or form, you have no choice. You don't have any leeway. You don't question it. You just take it the way it is. And I don't want to hear that the jail's too crowded. You have to obey the orders of the court. And she's so strong on this. We have a cite on that yet, Doug?
Yes.
All right.
It is 230 N.J.S.A. Super 223 1989.
All right. That's Judge Pressler's, right? Okay. Read over the
judge.
What's that?
A Bergen judge. I'm just saying. I'm going to cite her name. She's a Bergen judge.
So the bottom line is, if you have a commitment order that says X, that the guy's going to stand on his head at the jail, then he stands on his head at the jail. The sheriffs don't have any say in terms of how these people are supposed to do it. But this is the precedent you got to work with, Joey. So
yeah, let me tell you what a day in jail means. It means somewhere between 1 minute and 24 hours. So if your client is, say, sentenced by the court to say, look, at the end of the workday on Friday, you have to report to the jail at 7 p.m., and the sheriff has to hold you until 6 a.m. on Monday to allow you to go to work. That's 4 days jail credit. Friday, Saturday, Sunday, Monday.
All right, now, guys, I don't want to belabor this because we have some other things to do today. So let's just kind of touch on some of the remaining issues. Remember that it's a crime of the fourth degree, so the jail term can be as long as 18 months. If your guy got 6 months over the 18, he'd be parole eligible immediately, because typically you're parole eligible after 1/3 of your sentence or 60 days, whichever is greater. The statute does not call for any license suspension. There is no mandatory suspension under GC 4-26. The application of the 2-year suspension maximum under 2C43-2 probably does not apply as a result of the appellate division case State versus Gross, which says that whenever the use of a motor vehicle is an element of the offense, then in 2C43-2 should not apply. I don't know why I have this in here. There is no presumption one way or the other. There's just jail.
Wait a minute. I think that presumption of non-incarceration actually plays out here, and I'll tell you why.
Oh, why?
Here's what I'm thinking. The statute only requires 180 days. It says imprisonment, but I've gone through 2C. With Westlaw, it's pretty easy. And I find that the legislature alternatively uses imprisonment to mean state prison or to mean county jail. They'll say at some points, they say a 10-day period of imprisonment, on this motor vehicle offense. Well, obviously, they're not going to send you to state prison for 10 days on a motor vehicle offense. Here's what I think. On a fourth-degree offense, you could get a year or 18 months in state prison. And the judge could say, I sentence you to state prison with a minimum of 180. 1 year or 18 months. Then you go serve it at a state prison. I believe that he can make it a condition of probation. Say, I'm sentencing you to probation, 365 days probation, with a mandatory condition of probation of 180 days without parole in the Bergen County Jail. Now, if the judge is thinking of sending your client to state prison, which would be much more onerous, much more burdensome, he'd be around worse people, and he may be at a point in the state far away from where his family is, your argument is there's a presumption of non-incarceration. Believe it or not, under our case law, going to jail for 364 days is not considered jail. That's just a condition of probation. Now, you may be serving with a state prisoner who's in the next cell, who's doing a 1-year state prison sentence. You're in the same facility, same lockup, same food, same location. One of you's in state prison, and one of you's not in prison at all. You're just on probation. They just told you to serve a portion of your probation there. So I believe you can make the presumption, you can argue the presumption of non-incarceration to mean that you shouldn't get a state prison term. The presumption is you'll get a probationary term, and this has to be a condition of it.
State versus O'Connor is a Supreme Court case dealing with, these are called split sentences. And basically they take the position, say you're pure first offender, okay? All right, Mr. Johnson, you got the presumption of non-incarceration, you're a first offender, okay? I'm going to place you on a period of probation. You're going to start your probation by serving 6 months in the Bergen County Jail. All right? You say, what? What are you talking about? It's not really jail. It's a condition of your probation. You can get this in municipal court, too. You can get split sentences in municipal court on DPs up to 90 days. They can get 90 days in jail as a condition of probation. On PTI, these are all the appellate division cases dealing with PTI in the context of 2C 40-26. They're all rejections. And you have to think about it. Look, over and above the fact that your client has to be a scofflaw to be charged with this in the first place, you have the problem when anytime you ask for a PTI where you're going to walk away from a mandatory jail sentence, the law is really well established that unless there's something idiosyncratic about your guy, it's inappropriate to give a person like that PTI, okay? And your guy's an idiot, but he's not necessarily idiosyncratic, okay? Like somebody who's profoundly retarded or just is dying of cancer or something like that, where you just, idiosyncratic is the word. But apart from that, these people should not be getting PTI in the first place. So just kind of keep that in the back of your mind, guys, all right? Of course, if you're going to try to challenge the determination of the prosecutor's office for rejecting your guy from PTI, remember that the standard is going to be a gross abuse of discretion. Not even a regular abuse, a gross abuse, all right? Now, we got to talk about this merger business. It's very, very important because, because it is. So merger occurs when there are simultaneous convictions for lesser included offenses. Obviously, driving on a revoked list is a lesser included offense of 2C 40-26. So the 2C 40-26 properly would merge for sentencing purposes into the greater included offense. However, because of this terrible Bauman decision, let me just read it to you real fast. We conclude the state's only evidence of recklessness was intoxication. We are satisfied the drunk driving must merge into the assault conviction. But that conclusion does not dispose of the DWI penalties mandated by 450, including a 6-month DL loss. Those penalties, in our view, must survive the merger, particularly since they represent not only punishment for the offender, but also protection for the driving public, nor do we have any doubt that the criminal jurisprudence of this state permits the survival of mandatory penalties attended upon a lesser charge when merged with a more serious offense that does not carry those penalties. Now, this holding went to the Supreme Court in a case called State versus Wade, and half of a paragraph on one page, the Supreme Court says, that sounds pretty good to us, too. So Wade approves Bauman, and the point I'm trying to make to you is that the penalties on the 340 are going to survive the merger of the 340 into the 2C 40-26, meaning surcharge, license suspension, fine, jail, although I think they probably run the jail concurrently. You've got to deal with all this stuff. So tell your client, if the judge knows about Bauman or the prosecutor knows about Bauman, that they're going to sentence your guy to these penalties, notwithstanding the fact that the 340 gets merged.
Yeah, and this is no different in DWI in a school zone. As you all know, by the way, the school zone portion of 450 was eliminated by the statute that the Assembly and the Senate passed, the new revised DWI statute. However, Governor Christie refused to sign that statute. In fact, he specifically rejected it and sent back a revised version. But the point in what I'm saying is, you have the school zone offense. Now, you know that if your client's driving drunk and he's got a prior offense, let's say a year before, and this is a school zone offense, he is guilty of both, assuming that he's convicted, he's guilty of both driving in the school zone and driving while intoxicated. Right? Driving while intoxicated and DWI in a school zone. So two separate offenses, subsection A and subsection G, I think it is, of 39450. Now, here's the point. His first offense was just a straight non-school zone DWI. So he is a second-time DWI offender, but he is a first-time DWI in a school zone offender. So he gets sentenced he gets the first-time offensive penalties for a DWI in a school zone guy, and then you go back and look to see what are the penalties for a second-time DWI guy. And as the court says, you compare them. Whichever is the higher one, that's what he gets. So you go right down. He only gets one conviction, which would, in my opinion, be the subsection G, because that has the greater number.
No,
but it's the opposite.
It's the opposite. Yeah, that's what happened in Reiner. It was a second offense regular and a first offense school zone.
Yeah, and I think the one that has the more elements should be the upper one, and the one with less elements should merge. But that's not the way it is. But the point is, that's the way it is with an indictable and a motor vehicle ticket. If there's a greater penalty after you get him convicted of the 2C40-26 indictable offense, and the judge also logically convicts your client of the 39-340, he looks at whatever the penalties are down there. They rise up and become part of the indictable sentence. Now, normally they're not going to exceed them, but in this case they do, because 2C40-26 does not call for a suspension of your license, whereas the motor vehicle offense does. And the motor vehicle offense obviously involves a greater penalty if your client is driving on the revoked list.
Joe had made a reference earlier on to the procedure where the judge will sit as a judge, the Superior Court judge will sit as a judge in the municipal court and hear the ticket or tickets, because there may be other tickets associated with the 340, where the jury will decide the guilt or innocence on the 2C40-26 and other indictable offenses. Muniz is the case that stands for that proposition, and a lot of inexperienced attorneys aren't aware that you're going to have this bifurcated trial situation where you're really trying two different cases before two different fact finders simultaneously, but that's the holding in Muniz. Joe had mentioned and worked very closely with the assistant prosecutor to sanitize your client's driving history. You certainly don't want him seeing those 15 suspensions for Parking Offenses Adjudication Act and the other times he's been suspended and not paid surcharges. And oh, by the way, that vehicular homicide that he had when he was 18 years old, you don't want that showing up either. There's so much on there that could be so unduly prejudicial and really irrelevant to the issues of guilt or innocence. So, and I don't know that it does anybody any good to have like a 5-page or 6-page abstract that has a bunch of lines through it, lets the jury speculate.
That was one of the possibilities in my case, and I talked to the assistant prosecutor. I said, if we send in his abstract, Kevin asked this question, and there's things that are blacked out, the jury's going to say, oh my God, what was so horrible we couldn't see that? This guy really must be a danger to the community. We're going to convict him because he's got a 10-page driving abstract. Look at the weight of it. That alone means that this guy's a bad guy and he needs to be stopped and punished. So instead, the prosecutor went down and got 2 certified judgments of conviction, dispositions as they call them.
Just work with your assistant prosecutor to make sure that your client's record is properly sanitized. Joe and I, when we put this together, the only case we could find dealing with the admissibility of these abstracts in the context of 2C4-26 is Frieza. And again, it's not published, appellate division case, but it has zero scholarship in it. The court says the abstract is admissible in evidence. They don't say whether it's a business record, public record, or just comes in automatically. They don't deal with any issues. They just come out and say the abstract is admissible. All right, and Joe has already talked about the idea of the jury charge and this concept of knowing. I got to get a copy of that charge, Joey. So, was this helpful to you guys or a waste of time? I mean, did it kind of highlight some of the issues? Again, just out of respect to the judiciary and the prosecutors who are here, we're not advocating anything. This is just a black letter law presentation, but there's a lot of legal issues going on here, a lot of things that have to be decided into the future.
Yeah, and there's one last one. I mentioned it right at the outset. Remember, the statute says you have to have 2 prior convictions for 39:4-50. If you have a conviction in another state, you got to argue that the legislature did not say driving while intoxicated an offense, which could have generic application across all the states. It said 39:4-50. There's an unpublished case that says what that means is in any state. And your argument is, really, if they meant that, why didn't they put the language from 39:4-50 which says that? There was language that could specifically say that, and you chose not to put it in. Maybe they made a conscious decision not to do that.
Well, here's the situation, guys. The case Joe's referring to came out last week. It's unpublished, appellate division. Galdieri is the name of the case, Galdieri. It has 0 scholarship in it, which is why it's an unpublished decision. And they just come out and say that, under the 450 statute, it's anywhere in the state, anywhere in the country applies, which is not what it says at all. That's not what the case law says. It's just a very poor analysis of the law, but you're stuck with it at this point, at least as persuasive authority. Just make sure that, don't lose sight of the fact that the opinion has not been approved for publication, and make your argument. Joe's going to argue that you want to argue the rule of lenity, that these are criminal statutes that are to be strictly construed, and the legislature wanted to say, DWI or an offense of a similar nature in another jurisdiction. That's a big problem, because you got so many people be on the revoked list as a second offense because they had something in New York or Kansas or something like that.